Snow last night. So it's typical Vermont weather. We just have a lot less snow than we normally have. Nothing special. So anyway, this video is part 3 of the videos I'm making to satisfy the people in my comment section, saying they want me to prove my claims that I beat these charges. So I produced two videos already, one for 10 minutes that shows I beat them. Hang on a second. Yep. Sorry about that. This is the disposition on it. I showed on the first one. The second video, I provided a lot of text conversations between myself and my lawyer. I provided a video in there because when I was going through the text conversation, when I was speaking with my lawyer, I referenced other cases that I had going on, and I sent him a copy of one of my court appearances where the judge I lost, and that has to do with State Trooper Clay Knight with the marijuana and in the wrong bag and using my phone. I did a video on that previously. You can check it out. But the whole point of me putting that on there is because in open court at the end, I told the judge, like, F you. So anyway, I'm picking back up today, finishing out the conversation that I was having with my lawyer, and then I'm going to pick up with the conversation that I had with his paralegal. Okay. Let's see here. Okay. Might be better off going down here with this one up here, I think. See if I can do this. There we go. Okay. I know that's probably not very clear, but let me see if I can get it closer. Like I said, I'm not very good at this stuff. So, all right. That should get us about there. All right. It's a little wobbly. I'm using a tripod stick that I got from the fiance. Okay, so I'm gonna pick up from here. So I said to my lawyer, my apologies for such a long text last night. I was very agitated throughout the day. And oh, yeah, I covered that one last night. That's not important. Or last time. I covered that one too, where I referenced right here, where I said this to the judge. Okay. This right here, I was talking about some time I spent in federal prison. If anybody's interested in reading that, they should just screenshot it. I'm not going to read through it for the purposes of like time on this video. But it shows how the prison officials are, and they're pretty corrupt. So that's another page of it. Yeah, let me see here. I really do not care if I go back. Oh yeah, I care if I go back, but a lot of bravado. And then I said why to his, I don't know. Stevan said you said, something about that. He may have misunderstood. I did. I am just curious why you asked. I think that's about the competency hearing thing. What relevance does it have other than my mentioning it? I can assure you they find me competent. I was not even offended when they requested it. I did file a motion asking for modification of conditions to allow me to frequent Subway in St. Johnsbury, wherein I explained which sandwiches I like and how I do not eat the tuna. Okay, so that one's pretty funny. 1, 2, 3, 4, 5. Let's see if I can find it here. Because, yeah, these right here. So I drafted these motions to the court in the Subway restaurant thing, just because I was kind of irritated about it, and I just like to be an asshole sometimes. This letter is to act as a motion to modify conditions. I strongly feel that the conditions set forth in this case are an impingement on my rights and that they overstep the court's authority over my free will. Specifically, I'm requesting that the condition that I am not to go to the Subway restaurant in St. Johnsbury be rescinded. I make this request as I have not been convicted of any crime, nor has Subway denied me patronage via a no trespass order. I also make this request as I really enjoy Subway sandwiches. Specifically, I like their turkey and bacon ranch combo on Italian herbs and cheese bread with many veggies. I am also a huge fan of the spinach wrap with chicken and bacon along with a variety of vegetables. I never get the tuna melt, as I have learned that it actually contains no tuna. I always enjoy it with mayonnaise and a spicy mustard of sorts. I travel often through the St. Johnsbury area and would like to eat as I travel to Littleton, New Hampshire for supplies. This condition has impeded on my lunch and my rights. As such, I request for the court to modify and set forth conditions so I can freely stop at the Subway and purchase necessary food for my diet that sustains my life force. Okay, so I was just being a jerk there, filing motions with the court. Let's see what this one is. So this was when the state requested a motion for a competency/sanity hearing. This was my response. This is my see. I can write regular motions like legalese and with the proper form, but I don't because I'm not a lawyer and I can't be held to the same standard as a lawyer. The courts have already ruled on that. The Supreme Court has. So this one says, this is my motion in response to the state's motion for a competency/sanity evaluation in response to my motion for speedy trial. I do not object to this evaluation as long as I am not the one paying for it. I also do not object to this motion for the court to order a competency and sanity evaluation, quote unquote, owed defendant, as it shows how Orwellian the state is and their intentions that they cannot even spell check their motion in response to my invoking my right to a speedy trial. I also do not object to this motion as it is usually the duty of defense counsel to show pretense for quote unquote competency or quote unquote sanity, as it generally clears the defendant of wrongdoing. It makes me ponder if the state is attempting to get me committed against my will for advocating for my constitutional rights because the state simply hates the Constitution and those that fight to defend it. It also seems that since I did not choose to pay the extortion fee of $111.18 without a court order, that the state is retaliating against me with extreme, capricious, and malicious intent to thwart my invoking my 14th Amendment right to due process. I ask that the court follow its Constitution, the Constitution, and to make a ruling with the rule of constitutional law and justice. He didn't. He ordered the competency hearing. The psychiatrist even explained to the court that he couldn't do the competency hearing to see if I could stand trial because it would be an ethical situation for him, because they haven't even determined if I was competent to defend myself. So he recommended that they provide a lawyer for the competency hearing, but then the court can't force me to have a lawyer for that either. So it's a big mess, but we're working through it. The status conference is the 25th of March. Okay, so I filed this motion in response to the state's motion for a competency hearing. This is a motion presented by defendant Air Gravel requesting that the court order a competency and sanity evaluation of the Orwellian State Representative Maria L. Byford in regards to docket number 21 CR 03906, as it appears she has competency issues in regards to the Constitution, which is rising to the level of insane or psychologically unhinged. A competency hearing would also bring to light Maria Byford's grandiose and authoritarian psychopathic ideologies for the civilians that she's a public servant to. They denied my motion. Go figure, right? 1, 2, 3, 4, 5. I think we were here. Okay. Okay, so he goes, so his response is, I know they will. That's why I'm asking why. And I said, I did not object to the state's request for sanity and competency evaluation. I welcomed it as long as I was not paying for it. The court granted the competency evaluation, but not the sanity. The state never mentioned why they made such a request, and the court never asked in turn. I filed a motion for requesting the state attorney be evaluated in the same manner, but gave cause. My motion was denied. Go figure. And I sent him that. I'm not sure what that is. I think that was wrong. But anyway, I said, what charity are you donating to? Maybe instead of going to your office Maybe instead of going to your office to gracefully accept the state's dismissal of all fabricated charges, we can meet at the restaurant Friendly Toast by your office that serves drinks for lunch. You can buy. When can I expect the state to dismiss? Would you say this is true statement? Quote, lawyers never work for us. They work for the court. That's why they take the quote unquote bar exam and are the only professional group who is self-regulated, their crooked safety net to protect their asses. He never responded to that, and he said, just waiting to confirm with the state. And I said, at first I was really pissed about the fact I would still have to challenge the stop sign violation. A call from Sarah S. George to the Judicial Bureau would have dismissed the ticket after much consideration. After much consideration, I decided better for it to go to court. The judge there is an asshole and does not like me in the least. However, this time I'm going to surprise him with a different approach. The approach will be entering into the evidence all the video I have of the night. Speaking of evidence, I require all I require that you send all documents and any video evidence that you acquired from this. That you ascertained from the Winooski police while operating as a legal counsel, as I will enter that into the court as evidence in my defense of the fabricated infractions from that night. I will still request a jury that on the night of the stop sign violation at the beginning of the hearing. Please let me know how you would like to send delivery of the requested case file information. I'll be calling the Judicial Bureau tomorrow to inform them that the criminal aspect of the case is closed and that they can now proceed with the citation. I feel as though you fared very well in this one, and that despite our difference in opinion, that if it was not for my endless resolve at self-advocacy, that you intended to take my money with little where is it? Here we go. Take my money with little intention of working for it. In closing, Sarah George will most likely get to see me soon enough, as Walmart destroyed property very important to me and lied to me on numerous occasions to cover their actions. I will attempt to resolve using the Williston police, as Walmart staff called the last night, stating I don't know what I did there, stating I threatened them. I did not. Good times. Maybe I can you have me represent you. I don't know. So I don't know if I played this one. So he really pissed me off after a lot of this stuff when we were going through it. So
this is my deal, Jordan.
I sent him. I played this for you guys. I'm not gonna do that again to you then. Let me close this out. Open my file here. Oh shit. Let's go to history. Alright, let's look up, see, go to STV. Alright, so this is my lawyer's paralegal, okay? Let's see here. This is my lawyer's paralegal. This is the conversations that I had with him from the very beginning. Attorney Handy has a case update for you and like to schedule a phone call 11/1 at 8:30 a.m. Does that time date work for you? I go, okay, sounds good. Is there any reason why you can't email me for the update? I am presuming I am getting the email update, question mark. He says, Attorney Handy prefers to speak over the phone because he wants to discuss the case in detail with you ahead of time in preparation for the 11/19 motion hearing. Does tomorrow 9:30 a.m. work? And I said, I thought that was why I set up the call for this morning at 8:30. Sorry, I misunderstood you. I thought you wanted an email update, so I didn't set up a time. And I go, I see. My apologies for misunderstanding for my question. My perception was we set up a call from my response. As I did not get response to my question about doing it via email, I presume the call was scheduled, question mark. When would be convenient for him to call, question mark. He says, due to scheduling, we have to move tomorrow 9:30 a.m. I go, that should work. I think I will be home working on my court appearance for 11/3 for my marijuana being in the wrong container after I got pulled over for filming an accident. Should be very interesting. I am also prepping for my competency evaluation for the 10th for misdemeanor charges when I smashed up the chip rack on the floor at Subway and St. Johnsbury because they refused to serve me because of my medical inability to wear a face mask. The state's attorney, Mary Byford, is a bitch. The court denied my motion to have her evaluated, even though it was well articulated request. Tell your boss that if he's not prepared to go all the way, he can recuse himself. That's supposed to say recuse right there, and refund my money. Thanks. Attorney Handy believes that moving forward is going to be more detrimental to your case than taking the current offer. There will be requirements for reinstatement, like IDRP, which Attorney Handy is willing to pay for, and SR22 insurance. You're already serving suspension time, so there's only a couple steps left for reinstatement. I do not care, nor should he. I will never pay SR22 insurance, and I do not give a fuck if my license is suspended indefinitely. I will operate without both. The status conference should be as follows. We are prepared to go to trial. That is all. Do not come at me again with any of this type of rhetoric again. I told you guys I would be the easiest or hardest client. I want to be the easiest guy. I begin to feel as though I won't be. Not because I am that hard to deal with, but rather because I am invoking my right to trial, and that is time and money. I hope that clears things up. And I said, I just got off the phone with the DMV. I am not serving suspension time, and my license was reinstated on 6/16/2022 and will remain that way pending the criminal case. I do not understand what you're saying in your email. He goes, yes, I apologize. I misunderstood Attorney Handy. If you plead to the civil, the reinstatement requirements will take effect, which means that my license would have been suspended for 16 days. Because they had suspended it for 76 before I got it back, but I continued to drive the whole time anyway. So I sent him this. I said, no plea deals, and I found these cases interesting. And I can include a link to this Supreme Court case rulings for anybody that's interested in it. And that's this right here. Okay, so then I said, here are a couple links to some friends of mine. Their work is necessary, not really my thing. I prefer to smash up Subway restaurants and take my day in court. I have little patience these days. That was a joke. So This is my buddy Frank right here. Check out his content. He's amazing. He works with the homeless. Absolute Defiance is his channel. He's from Manchester. He lives in Manchester, New Hampshire. Awesome guy. Now, I was buffing a little bit. This is NH Press Now. I don't know him. I've messaged him. I'd like to do an audit with him because he's cool and collective and like. So anyway, if he ends up seeing this, buddy, let's be friends. Let me do an audit with you. Okay. So I said, where are my videos? I want this Winooski police CCTV body and footage and body camera footage. He goes, Josh emailed you the video. Now, Josh is the other paralegal or assistant, and he did email it to me. Like I said, I'm not going to show those because it's all of like the, it's irrelevant unless people want to see them. But I'm going to caution anybody that does that. I was having an issue with PTSD at the time, and from them doing what they were doing to me. So like I kind of was frantic and a little bit, I don't know what you guess what we call it. But anyway, I have no who Josh is, nor do I recall seeing said email. Josh emailed me the documents, no video. I see Josh sent 2 zip files. The second one will not open. Send it again. So then this was, he said, good morning, see attached notice of dismissal. That's that right there. I showed it to you guys already. And I go, does this include the stop sign violation? He goes, good question. Let me ask Attorney Handy and I'll get back to you. And I go, also, to be clear, this covers the civil DUI as well. Question mark? He goes, it does cover the civil DUI portion of the civil portion of the DUI. The tickets will have to be litigated by the Judicial Bureau, a separate institution from the criminal court. Like I said in one of my previous videos, I posted that with Officer Sharif in court proceedings, the whole deal, to show that I beat that ticket as well. And I was like, that is effing bullshit. This is all stemmed out of the initial cause of alleged running the stop sign, the underlying offense. Suppose there is no connection, question mark, I am pissed. And I go, I want a copy of everything from my case. Include all video evidence obtained from Winooski Police. Okay, we'll send it over as soon as possible. Okay, I don't know what this one is. Some kind of attachment, Vermont. Oh, that's the memo I sent that I played to you guys, where I was so pissed and I called Jordan Handy, and I just kind of went off a little bit. Okay, and this was him saying, good afternoon, Eric. The motion hearing scheduled for this Friday is canceled. Attorney Handy is priorly engaged, whatever. Whoops. He told me that. Okay, and the hearing give the right to record. Oh, okay. He told me that he was going to file a motion to move the hearing. I am more curious about being given the right to record the hearings as the case moves forward. Thanks. They never allowed me in the courtroom. I never, one time in that whole case, was allowed in the courtroom. I got into the court building twice, but only to the clerk once and not past the doorman the second time. And I even gave him a medical pass saying I can't wear a mask. So he says, good morning, Eric. Yes, Attorney Handy filed a motion to continue the hearing, which was granted. The court will reschedule. Okay, that's settled. Now I want efforts made in ensuring I am able to record the court hearing. From what I read, it is best to get the judge to approve such a thing. Please email me a copy of the motion sent to the Judicial Bureau regarding my civil license suspension. Thanks. He goes, here you go. So this is what it is. I want to open it, but I don't want to open it because I don't want to lose this page. Well, I go, thank you. But in it, he said, I'll get to it in a second, but you'll see. And I go, thank you. And then this is my response to it. I said, I just read the motion. I asked that before any further motions be filed on my behalf, that they are sent to me first. I am not difficult to deal with, but certain language used is important to me. I do not like definitive No, I didn't spell definitive. Definite words pertaining to my knowledge of things to go with the word understood or any derivative thereof. Understanding is standing under, and that is not my objective here. I would prefer some roundabout language such as, after being retained by my client, I discovered and conversed with my client about it and determined that was the best interest of my client's needs. Because once you say you understand, you really say you're standing under what they're saying and doing. And I don't go for that. Okay. Now this was... Okay, this is the letter I told you I was offering. The state will have to provide professional witnesses to combat my professional. Someone who put his license on this letter and can be used as a witness at trial. That is two witnesses and a professional witness in my defense against two shitbag cops and a rookie there shitbag training. Please be sure Jordan reads it and gets back to me before he divulges any of its contents to the state for their boss, the court. I also have been doing research. I will put together something for Jordan's review. Thanks. And that is a letter from my a guy that I saw after my car accident where I had a brain injury, that talks about that I have PTSD from prison and a traumatic brain injury, which messes with my autonomic nervous system, which gets me I go into fight or flight when agitated very quickly. Okay, and he goes, received, thanks, I'll bring this to Jordan's attention. I go, thank you. I'm sure its contents and context brought with it a plethora of thoughts as to the direction of this case can go. With that, I hope it brought laughs to the room as well. Thanks. And I go, what is the status of my case? Let me reach out to Attorney Handy. Once I have an update, I'll let you know. Jordan called you a short while ago to give you an update, but you were probably busy at the time, unable to answer. Can we schedule a time to talk tomorrow, say 12 p.m.? And I said, I spoke with Jordan briefly. We got disconnected. My desire is as follows. Tell Sarah George she'll have to hang her coat on another hook or work to do so on this one. That I accept no responsibility for any of the things I am accused of, and I'm unwilling to accept any plea deal with the state. That I have 3 CC, actually that's supposed to be 4. I have 4. I have 3 CCTV cameras and 2 cell phones that clearly catalog the whole incident, and I have 2 witnesses along with a professional witness for trial. I hope that clears things up. Understood. Information was relayed to Attorney Handy. After consideration of the case, I decided I want a jury trial without question. Please ask Jordan not to come at me again with such a thing. If he is not up for the case, he can recuse himself. He said he's up for it. Time shall tell. Okay, I'll let him know. Tell me, okay, if he is up for the case. He said he is. Please explain. Will do. Morning. I wish to video record all court appearances. Not sure if the motion is needed to get permission from the judge. Thanks. Good morning, Eric. Let me relay this information to Attorney Handy and get back to you. Sounds good. There should be no issue with it by the court. I just read Vermont Rules Criminal Procedure 53, Section 3. I want to record my hearings. Oh. Is this the one I just read? So I said, since I have not heard back from Jordan yet, I would like to say how I would like to proceed. I want to hold the letter close to the chest to tell the state of its existence and our desire to use it and its writer at trial. Thanks. I'm talking about my professional witness there. Okay, just did that one. This is a status conference. Good afternoon, Eric. You have a status conference July 1st, 2002 to 3 p.m. The WebEx link as follows. And I think that's the WebEx link. What is the strategy for the status conference? I hope it is respectfully request that the state drop their fabricated charges and to have the officers held responsible for dereliction of duty and for violating my rights. Sorry, that's the washing machine just went on. What is the strategy for the status conference? I hope it is. Oh, I read that. The motion to reopen your civil suspension process was granted, so Attorney Handy will acknowledge the civil suspension and enter a denial in that docket. That should be pretty much it for the hearing. After that, the court will schedule a hearing, and Attorney Handy will ensure we have all the evidence ready for review and negotiations. Awesome. I guess I do not need to be there for that. Seems futile and a waste of time. As far as negotiations go, it is simple. Dismiss the charges or set up a trial date. Nothing in between. Thanks. I just reread your email. The part about acknowledging the document in civil suspension has been lifted and enter a denial in that docket. Which docket? Neither criminal charge was alcohol related. The criminal and civil cases have docket numbers associated with them. The civil docket number and the criminal docket number. It's how the court distinguishes the two. I just mean that Attorney Handy will enter a denial in that civil case. Does that make sense? Sorry if it was a bit confusing. I got it, thanks. Okay. Content was unavailable to load. Don't know what I sent him. Okay, well I have it. I'm very technically inept. Anyway, a few weeks back I noticed, oh that's what it was. I noticed a suspicious black SUV parked up the road as I rode my bike. Yeah, that shit's irrelevant. It's just about some stuff. So I watched what's going on out in front of my house with my cameras because I've had some issues with theft and shit like that. Okay. So substance abuse assessment. So they wanted me to do a substance abuse assessment. I tried to, and then I was like, whatever. This lady ain't trying to deal with me, so I decided I didn't want to do it. Attorney Handy believes the best approach to resolving your case is your favor would be for you to schedule the substance abuse assessment with a psychologist as soon as possible. It shows the state that you're being proactive in your case, which may also allow for leniency from the prosecuting attorney, and it gives us a bit more negotiating room, potentially resolve the case in your favor. I would recommend that you contact Dr. Hauser. Her contact information is attached below. Be sure to let her know that we referred you to her, and keep me updated on your progress too. So after I spoke with her, my determination is that she's just a paid shill, and she'll say whatever is needed to be said depending on who's paying her to say it. I decided not to do anything with her. This is her information right here. I don't know. I'm not going to pop it open. So what he's referring to is, because their intention is to have me plead out to a DWI, and I'm not doing it. So I don't need to do a drug assessment because the DUI was dropped by the state, and I was given careless and negligent, but because they said I refused, I still had a civil DUI. So they try to get you in coming and going. I said, my immediate response is to state that I'm not doing it. After reading the entirety of your email, I understand now that a meeting with Dr. Hauser could be beneficial in this case. The prosecuting attorney need not to show me no favors under the guise of leniency. She has attempted to prosecute a fabricated case. Once Jordan proves my innocence, I expect I will be compensated for any further expenses I will incur during this charade, which may include Dr. Hauser. I will state this. I will not subject myself to giving any of my body fluids to anyone at any time, and that I hope Dr. Hauser are okay with those unable to mask. Attorney Handy said, no worries, not doing the substance abuse assessment, that's fine. I do not have a problem with doing an assessment. I have done a few. I understand how they work and the importance of honesty. I also believe an assessment would be beneficial. I was just stating that I will not subject myself to taking of my body fluids for any reason. I do not believe that that is the case here with the assessment, but if it is, I am out. I am not out for certain. I have contacted Dr. House's office and left a voicemail. Please let me know when you hear back from the civil court for regards to my license. Thank you. Okay, that makes sense. Thank you for clarifying that for me. Please keep me updated regarding the substance abuse assessment. I said, good morning, received a call from Dr. Hauser and emailed her about setting up an assessment. Any word on my license? Okay, so essentially what I was saying, saying understand the importance of honesty. I was essentially stating that I was going to lie to her at all costs, if had to, and she was recommended for that reason. I don't remember what this video is, but I think this is my buddy Frank again, going hard in the courthouse from Absolute Defiance channel. Check him out. He needs the love. Yeah, Absolute Defiance. He goes, thank you for the update. Regarding your license, you will be under suspension for the failing to submit the civil paperwork in on time. I'm drafting the motion to reopen your civil suspension and set aside the default judgment. So I read these backwards to you apparently. No big deal. Yeah, I'm done reading them, but you get the idea. This is just me stating like that I won't be able to be there for a hearing because I was going on vacation. They didn't need me there. This right here, all right, I'm gonna play this video for you though because we're right here. I hope the link will open. So the same police officers did the same thing to another guy right in front of my house. Let's see if this bad boy opens. I hope it does. Okay, so if you look right here, okay, if you look right here, you'll see the cops follow this guy, lights on and sirens, and pull right into his driveway, okay, and they leave a few minutes later. The same distance that I traveled from there to here and pulled into my driveway, and I got arrested and my phone thrown. That's my Alpha. That's my car I get in so much trouble with. See, does this look like this guy's stopping or sirens, like sirens and lights? See, so they shut off the sirens. They didn't do that in my house. So, but within a couple minutes, that guy was, they were gone. So yeah. Okay, so I think that pretty much, I'm gonna back up a little bit. I'm not sure what it looks like or if you can even see me. I think that pretty much covers it. For any of the people that were questioning whether I dismissed those charges or not, I gave you the full breakdown. I don't have the actual court appearances because, like I said, I wasn't allowed in the courts. But that was all the conversations between my lawyer's paralegal, my lawyer, the conversation between my lawyer, wherein he tried, like, it's a corrupt system from its core, and I'm going to be going to the city council meeting. I'm going to be outlining all of this. I'm going to put together a really good presentation with video. I know the city council members are same, you know, same shippers, you know, same arms to the same, you know, I don't know, cogs to the same wagon, wheel. I don't know what the hell I'm trying to say. But all I know is that their ideology is to create revenue at our expense and to take our rights from us, and I don't like it. So anyway, one last time, it is dismissed, all charges. So much love to everybody. I'm gonna do some better content soon. I'm learning the editing. It's slow. Till next time, peace out.